Welcome to Heritage University Presents All Things FHA Part 2. My name is Melissa Rogers, and I'm the Vice President of Business Development for Heritage Property Management, and we are so excited that you've joined us for the second part of a two-part series where we've had the privilege of having partner Cynthia Hodge of Lueder, Larkin Hunter kind of give us a great explanation about all things fair housing. So tonight's course is going to be jam-packed, just like our first course, and we gently ask everybody that's in attendance that when we get to the Q&A section, that the things that we're going to be talking about today are going to be very, very high level. And so as you are starting to think and generate questions that you're going to submit throughout the course tonight, we do ask that you also keep those high level, and any pertinent association requests or thoughts pursuant to your particular community, we do ask that you reach out to your current counsel for any guidance related to this. Again, Cindy's going to be talking to us in totality about the topic itself so that you can have some good, decent education about what we're going to learn this evening. For those of you that are joining us for the first time, we're going to go over just a few housekeeping rules so that you can go ahead and enjoy the experience that we have over the next course of 60 minutes. The Q&A is going to be held until the very end of our conversation this evening. And as we go through the presentation, you are more than welcome to submit your questions in the upper right-hand corner in the Q&A section. And we are actually going to be monitoring that as we go throughout. However, we are going to keep the question and answer session addressed at the very end. So hopefully most of your questions are going to be answered as Cindy actually goes through the discussion this evening. So without further ado, we are so excited to have her returning. I now introduce you to Cynthia Hodge.
Thank you so much, Melissa, and welcome everyone. I hope I have many that attended in January, but for those who are just now attending, I'm going to make sure I do a quick review for you as well so you can be brought up to speed. I have been asked to present All Things FHA, and so again, as Melissa said, this is part 2. And we're going to cover a lot of ground tonight. Before I begin, I do want to give a big thanks to Heritage University, to Melissa, Kate, Josh, and the whole Heritage leadership team for inviting me as a guest presenter. I know that you are going to have an assortment of classes throughout this year, and I hope you take advantage of as many as possible with many wonderful guest presenters through Heritage. And so I'm just very grateful that I could be in your first 2 months of this year. So just to recap, last month, we went over the basics. We went over FHA's impact on community associations. We went over reasonable accommodations and modifications, service animals, emotional support animals, and how insurance plays a role. We covered a lot in an hour. So tonight, what we're going to focus on is how to avoid these costly discrimination claims and how to navigate challenging homeowner disputes. I'm going to provide some tips on how we do the analysis because, again, it's hard to explain this in a few slides. So the best way I could do it is to come up with several case studies that are based off of real life scenarios that we have experienced and talk through it with you. So we're going to go through the analysis together, step by step, so you can kind of have an understanding of what took place and how we arrived at the conclusion that we did. So there's at least 3 case studies that I'm going to go over with you all tonight. Again, as Melissa mentioned, it's harder for me to provide advice if we do have questions at the end that are very specific, even if we use the fun words of, suppose this is a hypothetical, hypothetically speaking, what about this? But the reality is that I would definitely want you to ask very specific questions of your association to your legal counsel. I don't want to step on any toes and provide that sort of advice, but general questions, I'm happy to answer and do my best at answering both tonight as well as perhaps after the class too. If we're not able to cover all of the questions, then I can do my best to answer those and provide those to those in attendance. So quick review for those who were already here last month, you're going to know these slides. You're going to know this. I'm going to solidify this information for you. And for those who weren't, I just want to make sure we're all kind of on the same page. So just very quickly, we are talking about fair housing, and fair housing has different parts, but I want to focus on the federal law and the state law, which fortunately are identical. But there's a federal body of statutes that prohibits discrimination in housing based on our protected classes. And following that, Georgia adopted, said, hey, copy and paste, that looked great. We want to have an identical set of statutes that prohibits discrimination in housing. So when we violate one, we're violating both. Now, those protected classes look something like this. We have 7 protected classes ranging from disability or handicap, race, sex, color, national origin, religion, and familial status. That's usually how I call it, but this one says family status. So those are 7 protected classes. And it is illegal for landlords, sellers, mortgage companies, and community associations to engage in discrimination of these protected classes during the course of any housing-related transaction. Now, what does that mean? Well, it means that there is a definition in the Fair Housing Act that's a housing provider, and associations are included. So this is any type of association, right? This is your property owners association, your condo association, your homeowners association, your townhome association, your swim and tennis club. You get the gist, right? So I use this as a visual model of kind of showing the range of types of communities that we have. All of them are going to be considered housing providers under the Act. And you may ask yourself, well, we're not selling or buying or, we're not helping people buy or sell property or lease it. That is true. However, as a housing provider, it's also the provision of services and facilities in connection with real estate. And that means having common elements that everyone can benefit and use, having common areas that everyone can benefit and use. So the fact that we do have real estate and can provide facilities to our members and their guests, that puts us into the category of being a housing provider. All right, so those are the definitions to bring everyone up to speed. I want to focus on really, aside from disputes, reasonable accommodations and modifications are probably what we see the most in community associations. These are requests that are being made with someone who has a disability, who is asking for either, as I pointed out, a reasonable accommodation or a modification. Let's go over the definitions real fast. Then we're going to do a case study. We're going to give a specific scenario and walk through it just so that we understand what this all means. So, under the Fair Housing Act, a reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that's necessary for that person with disabilities to have an equal opportunity to use and enjoy a dwelling, including the public and common use facilities. So, easiest way to explain reasonable accommodations, it's a change to a rule. It's a change to a policy. For instance, best example is someone needing to request to have their service dog or their emotional support animal be living with them when you may have a rule or policy or covenant that says that that specific breed or that specific animal is not allowed, right? So they're going to be asking for permission or an exception to a rule that's in place. Another example would be having a parking. Let's say you have a parking lot or a parking deck and someone's making a request that a parking space be moved closer to their unit to assist them because of their disability, right? So things like that are a reasonable accommodation. Those are the 2 easiest examples I can make. Now, since these rules, policies, practices, services that associations have can have a different effect on persons with disabilities, treating persons with disabilities exactly the same as everyone else can have a disparate impact, right? It can deny them equal opportunity. That's why we carve out the opportunity for requests and exceptions. But just because someone makes a request does not mean it's automatically approved, right? There has to be a couple of criteria that is met. And the most important one is really the nexus or relationship between the accommodation and the individual's disability. Let me explain. Someone wants to make a request, let's say for an emotional support animal to be present. They have to explain through perhaps a letter from their doctor why they do have a disability and that this is benefiting them and will alleviate the symptoms that they have. And therefore, there's a nexus. So them living with that pet provides that relationship that they would need. Now, an easy question to ask always is, well, does that mean we can deny requests? And the answer is yes, you can deny requests, but we have to make sure that it falls within one of these criteria, at least one, let me say that. One, it would be that if the person is not disabled as defined by the FHA, you could deny the request. Number 2 would be if there's no nexus, right? There's no relationship between the disability and the need for the accommodation. And the third reason would be that if the request is unreasonable. Now, let me be clear. In the legal context, the association is never going to I shouldn't say never, but probably not ever, go after the requester for number one. And what I mean by that is that we're not going to challenge somebody's disability and challenge that they're not disabled, or say that we're denying it because we don't believe you're disabled. That's really not an argument that the association really wants to make. Normally, when there is a denial of a request, it is because there is no nexus or the request is unreasonable. So just want to clarify that, even though those are the three criteria, typically the association is not going to be making the argument that a person is not disabled and try to challenge on that grounds. But you could ask yourself, well, what is unreasonable? And the answer to that is, well, it depends, right? Examples would be that something that's being requested is going to impose an undue financial or administrative burden, or it's going to fundamentally alter the nature of the association's operations. Easiest way I can explain it is that it's going to be on a case-by-case basis, right? We're going to have to look at the facts, look at the accommodation request and what's being asked and how much it costs, what are the financial resources of the association, what sort of benefits this would give to the requester, and are there other alternatives, right? So there's going to be a case-by-case basis that we have to do that analysis. Now, if we deny the request, the association can deny it and offer to make changes that don't pose such a burden, meaning kind of like a counteroffer in a way, right? We're offering to give a different proposal than what they are asking for in the hopes that we can reach a resolution. That could be paying for a less expensive partial accommodation, or combining funds with resources that the resident may find, or waiting until a later time when we've been able to secure the appropriate funding. No matter what, if we do enter into an agreement like this, we need to make sure it's in writing. And with regard to that first category of whether a disability is obvious or known versus not obvious, might be something that we cannot see. An easy example would be if someone has an emotional disorder or is diabetic, might have a heart condition. We can't necessarily see that, but they can provide third-party proof, right? They can provide a letter from a doctor or medical professional, a peer support group, a non-medical service agency, or even a reliable third party who's in the position to know and be able to provide verification of it. We're not going to ask for medical records, but they can provide this information to us as evidence that they do have the disability without us asking for too much. Now, that's reasonable accommodation. The other typical request that we see in our association world is a reasonable modification. And under the FHA, that is a structural change made to the existing premises, occupied or to be occupied by a person with a disability in order for them to enjoy the premises, to afford them full enjoyment of the premises. So whereas an accommodation is changing a rule or creating an exception to a rule or policy, reasonable modification is a structural change, right? It's kind of like the ARC or ACC, right? We're making a change to the exterior of something. Easiest examples is, as this picture shows, someone who wants to install a ramp or to install additional aids to their dwelling to be able to have easier access to it. Extending their driveway to be able to allow for medical aid devices to have an easier time getting in and out of vehicles, etc. These would be kind of easy examples of a structural change being asked for. And it is illegal to refuse to permit residents with disabilities to make modifications, even in the association's facilities. But keep in mind, in this situation, for modifications, we can require the owner to submit plans and to pay for reasonable modifications and restore the property back to its original condition when the modification is no longer necessary. So just a couple general reminders is just for these types of requests, and these do happen fairly often for different communities. We want to make sure that our communications are confidential. So the board needs to make sure that they are not communicating with the membership and not disclosing this information, but they're talking with the requester. They can talk with their counsel and their manager, but you're keeping this types of discussions confidential. And what I want to stress is you have to act timely and swiftly. You cannot delay. And while there's not a set time frame that you must respond within 7 days, our recommendation always is that you should be responding with 7 to 10 days and keeping things moving, because you don't want it to appear as though you have had an untimely response that could look like a denial. That creates the discrimination claim, right? That creates the complaint that could be filed because you've waited too long. So always make sure you're acting timely and swiftly. If, for instance, you get a request, don't wait 30 days until your next board meeting. You should be talking about it sooner than that. So that's the quickest recap. I know we don't talk about as much with animals and whatnot. That was in our first hour. Hopefully you can go back to that material. But that's kind of covering the very broad basics that we need to move forward. So in order to talk about reasonable accommodations and modifications, I'm going to give you a scenario. This is based off a real life scenario that our firm has experienced. Names, of course, and have been changed. You're not going to know what it is. But I'm going to read this to you and I'm going to walk through the analysis with you. All right. In this situation, John Deere is a veteran and he lives in Shiny Gates Townhome Association, Inc. And he does not own property outside the footprint of the unit, meaning it's kind of like a townhome community that's constructed more as a condo or under the condo construct, meaning that the unit and the boundaries are what the owner owns, and outside of it are the common areas or elements that the association maintains. All right. So John is a gardener and he has installed recently 15 large boulders to surround some planting beds. Some of the boulders are made of plastic. This is no joke. This did happen. He did not get approval from the ACC. And not only that, it's also on association's property. Remember, that area is not within his unit boundaries. Okay. So the association tells John that they can move the boulders off of their own property. And John requests a hearing. So the board meets with John. And at the hearing, John brings a letter from a VA doctor explaining that he has PTSD and that the boulders are necessary to increase his perceived sense of safety. John explains that he is concerned that a vehicle may roll down the hill and crash into his home, and the boulders would prevent that. The association denies the request for modification and demands that the rocks be removed, and John threatens to file a HUD complaint. Now, let's talk about these scenarios. So is John Deere disabled? So having PTSD would definitely qualify. So he would meet that term that he falls within the FHA's definition of disability and would be considered disabled. So can he make that request? Yes. Now, the next question in the analysis would be, are the landscape enhancers necessary to curb his PTSD? Is there a nexus? And from the fact pattern that I'm giving, but also based on the real life scenario, the answer would be yes. And here's why, is that even though we ourselves may not see this as being creating any greater sense of safety for some people, for John, it does. And for someone with PTSD, this does increase his perceived sense of safety. And having some sort of physical barrier or structure, even though they're plastic rocks right now, we'll get to that in a moment, but the structure itself does provide it. So there is a nexus. There's a relationship between him wanting to have something there and his perceived sense of safety. And we have to be open to these ideas because we have to realize that even though we may not see it that way, someone else can. So would I say that there is a nexus? I would. Now, the next question, though, remember, there's three components. The person is disabled under the FHA. Is there a nexus? And is the accommodation reasonable, right? Those are the three kind of questions we can ask ourselves. And if I ask that question, is the accommodation reasonable? I think there's a reasonable argument to say, no, it's not reasonable. And here's why. The presence of these boulders, and let me make it clear, these are large plastic boulders, are creating somewhat of an eyesore. There are people who are complaining, and in our real life scenario, there were owners who were complaining about the presence of this and the way that it looked, right? So the accommodation of what he's asking for to stay is probably not reasonable because it could detract significantly from the property values as well as the overall aesthetic of the community. Okay, so from the denial standpoint, there might be grounds under that term. However, and in the real life fact pattern, is there any alternative to allowing the large boulders? And I would argue, yes, there would be other alternatives. What if there could be an agreement between this owner and the association for a different type of retaining wall, something that's much more aesthetically pleasing, something that looks much better and would enhance the overall property, for which if this owner was willing to pay for a portion or most of to be able to have there, that is something to consider. And so what I want to point out in the real life fact pattern, that's what happened. The boulders were removed, especially the plastic ones, but there was a wall that was built to be able to, again, meet the need of this request, but for it to also look more aesthetically pleasing. So just because someone's making the request doesn't mean we have to accept it as is. there could be alternatives that would be a better resolution for all parties. But I hope that that makes sense to you. I wanted to utilize that as an example because reasonable accommodations and reasonable modifications can somewhat be confusing. So the main thing and what I want to recommend when you have these types of requests is, again, keep confidential, speak with your counsel, make sure that you're giving timely responses, and really keeping an open mind and looking at the perspective of the person making the request. All right, so that's from last time. Now we're going to focus even more on homeowner disputes, as well as trying to avoid these costly claims. I mentioned some of these statistics last time, but I just wanted to highlight again because I think it's important for us to keep in mind why we're seeing this trend, upward trend of discrimination claims being filed, what we're seeing nationwide as well as in Georgia, and then just how that applies to our associations. So in case you're interested, you can go online to the National Fair Housing Alliance. That's where I found this information. This is the second year in a row that they've done this report. This report was not conducted before. The first one was the 2023 Trends Report based on 2022 data. The 2024 Fair Housing Trends Report that's currently there is based on 2023 data. And I believe in August or September, they'll update again with the 2024 results. But just so you can see, there are 34,150 fair housing complaints received throughout the country. This is not just Georgia. But that's a significant increase over the last 5 years, and especially even since 2022 when it was only 33,007. So we're seeing fairly large increase in the amount of complaints being filed. Private nonprofit fair housing organizations processed over 75% of those complaints. Discrimination based on disability continues to be the majority of complaints filed, so over 52% in 2023. There were 1,521 complaints of harassment reported last year, which was an increase of 66 and 2/3. Sorry, I said that wrong. I looked at it and I said it 66.23%, so a little less than 66.25%. And there were 824 complaints based on color reported last year, which was an increase of 35.3%. So all of these are fairly large increases of harassment. Complaints based on color. Disability continues to be the vast majority of complaints that are filed. If you go to the website and you look at you can look at any state. I just pulled Georgia so that I could show you here. This is what, based on the report, that again, disability was the vast majority, over half of the total complaints that were filed, followed by race, national origin, and sex. Now, I mentioned in January too, one of the reasons why we have these rules changing and updating is because we're starting to see continuing increases of harassment and hate crimes that take place at or near someone's home. And the statistics do seem to show that roughly a quarter of all hate crimes happen at or near someone's home. And the HUD secretary, who's responsible for administering the Fair Housing Act, enacts rules, and these have been updated time and time again. But the one that's most significant that I have to talk about with you is the one that took place in 2016. And this rule was amended to address quid pro quo and hostile environment harassment. And HUD was concerned that the safety of one's home was being compromised and needed to address this. And this may trigger further analysis for us when we're dealing with these types of FHA discrimination claims. So this is the actual statute itself. Let me break it down a little bit more. The rule creates 3 categories of direct liability that would affect community associations, including 1, liability for the housing provider's own conduct. That would be the board member, right? A board member or officer whose conduct is creating perhaps a hostile environment. Number 2 would be liability for failing to take prompt corrective action relating to the conduct of employees or agents. That would be if you, let's say you lived in a high-rise community, condo community, and you have employees that they are salaried employees by the association, right? They are on the budget, and concierge, that sort of thing. That could be an employee of the association or an agent, a managing agent, right? That would be an agent of the association. And then there's also liability for failing to take prompt corrective action for the conduct of a third party, such as another resident. Now, I highlight here may be liable because this is not all of a sudden now the association's liable for any of these interactions. It just says that the association may be liable for under FHA for discriminatory impact of residents who harass or create a hostile environment. And I'm going to explain the analysis for that. Let me do a quick timeout for just a moment and explain just two different categories of homeowner disputes. Because sometimes when we think of, homeowner disputes, we think of, any dispute. Let me be clear, when we're talking about FHA, it is regarding harassment or discrimination based on someone's protected class. Examples would be providing or somebody saying racial slurs or slurs that are derogatory in nature, that are directed towards someone's race, sexual identity, color, national origin, right? That is a scenario that we are kind of dealing with in the context of this HUD rule, as well as the scenarios that I'm bringing up. So keep that in mind, versus there can also be homeowner disputes just based on perhaps other nuisance types of situations. Examples, maybe you have neighbors who do not like each other and they complain when someone has their next door neighbor has a party and they're, too loud, or they're playing music at the pool too much, or something like that. That doesn't necessarily bring this into the context. Those are homeowner disputes, but those are related more towards perhaps a noise or nuisance issue, not under the guise of discrimination under a protected class. I hope I can make that distinction clear in my examples, but I just want to make sure we do see that there is a little bit of a division of the types of homeowner disputes, and that we're focusing on the ones that deal with those in protected classes and that are being targeted under those protected classes. So let's do a definition. What is hostile environment harassment? It is defined as unwelcome conduct that is sufficiently severe or persuasive and interferes with the use or enjoyment of a dwelling or the provision or enjoyment of services or facilities. Now, before I go into our scenarios and talk them through, let's just talk about how we can prevent a complaint. Now, you could say, Cindy, this is very idealistic. Yes, we're going to educate and we're going to put in policies in place. But the reality is that is how we can prevent complaints. We keep things informed, we educate ourselves, we educate others, and we put policies and procedures in place. Let me explain. First off, how can education look? Well, it could look like what you're doing right now, which is fair housing training for board members, homeowner leaders. It could be fair housing training for management. I know that I did a 3-hour FHA course for 13 different companies last year. So I know that there are many management companies that are retaining that sort of advice and getting that training on a regular basis. Additionally, from a community standpoint, you can also send information to community members, sending reminders, having civility pledges, making sure people are aware that, your community is a safe and loving place to live. Again, I realize that sounds somewhat idealistic, but the truth is that education is essential. And it is our job to make sure that we factor in this in our newsletters and informational blasts. That can be not only newsletters. I mentioned here that you can have town hall meetings. You could do fair housing training, or even have an opportunity at your annual meeting. You could adopt policies on fair housing. And that can look like putting in a non-discrimination policy that says FHA applies here. There's a great importance of diversity. We address how our complaints will be handled if we do receive certain complaints. You can even do an annual review with the board and members at your annual meeting, right? Your annual meeting doesn't just have to be the president report, the financial report, and your election if you have a quorum. You can incorporate other parts of your presentation and make sure that people feel informed about it. Your board can do an ethics or civility pledge. Now, again, there's no law that says they must, and there's not probably anything in their bylaws that says that they have to sign it or else, but you can encourage that sort of voluntary cooperation, and having that pledge be signed every year or when a new board member comes on as a reminder of what they're agreeing to and making sure that they uphold. You can even post fair housing logo on your community facilities, right? So these are just some examples. This is not an exhaustive list, but I wanted to give some examples of the types of policies you can put into place and act as a reminder. But it would be remiss if I didn't also turn, the camera, I guess the camera is on me, but to turn it to myself as well. Like as an association attorney, myself and other colleagues in my industry, we have to be able to assist boards with analyzing these types of claims that come through, making sure that there's a timely response that's issued to the aggrieved person, educating the board in executive session, perhaps a specialized training, following up on these responses and advising whether additional actions are necessary. So it's equally important when I'm made aware of these situations for my clients that I'm handling it in a serious manner, because these are serious situations and we don't want to be dismissive. I hope this is the most productive or helpful slide. I've at least been told that it is when I've taught other classes, but I tried to compile how you would do the analysis when you have an FHA complaint. So again, you're having someone who's coming in saying that they have been targeted based on one of the protected classes, and they are asking for assistance. Rather than just saying homeowner to homeowner dispute, we can't do that. We have this HUD rule in place. We need to evaluate. We need to take these steps to analyze this and determine if we can do anything. The answer may be that we can't. We don't have anything in our governing documents, but we have to get through that analysis first. So if anything, what the HUD rule says is we just need to go through this analysis step to determine if we can take any action. That minimizes our liability exposure. So here are the following questions that I would ask in a situation like this. The first one would be, is the aggrieved person, the person who has brought this to the board's attention, are they in a protected class? Question number 2, was the conduct that they received, was it unwelcome? Number 3, did the aggrieved person have the right to enjoy their home or use the facilities or have services provided, participate in association function? Maybe it happened at a party for the association at the pool, right? Was that interfered with by a third party? And then the last question, and probably the most significant one, determining whether or not we take action, is, does the association have the authority in their governing documents to correct and end the discrimination? Right. So, and the answer in that situation may be we don't. We might not have anything in our governing documents, but we have to do the analysis and determine if we do. And when I say that in terms of further analysis is, where did the conduct occur? Right? Did it occur on the common area or the common elements? Does the association have control over that? Does it have rules in place on how people are supposed to conduct themselves? Do we have the authority to exercise control over signage or flags or behavior, nuisance noise, and have we put those into place so that we could rely upon that, right? And lastly, do the governing documents have a provision that says all owners and occupants must comply with all local, state, and federal laws and regulations? And now that's an important one. And I'm going to say this, I can't give you a percentage of how many associations have that language in their governing documents. Many do, many don't. That's just the fair statement. I will say a lot of condos will have that language kind of automatic. I think that was kind of part of whatever scheme in the condo documents done back then that have kind of transition incorporated. But I have seen many HOAs and POAs that also have that kind of catch-all provision. And the reason I point it out is that if that catch-all provision exists, what it means is if that person was, and I say the person, that third party that was saying something, doing something that made conduct unwelcome to the aggrieved person, and it falls within a protected class, we could say that they're violating the HUD rule, right? They're violating the quid pro quo and hostile environment harassment rule. And they're violating the FHA. So it gives us grounds, so to speak, for being able to say that that's a violation. If we don't have that language, then we might have to look at to see if there's anything else. And if there is not, then we might not be able to take action. And that's our ultimate analysis and conclusion. But assuming that we do have a provision or something that we're able to do, here's what what the first steps would be. So the first course of action, assuming that we can answer yes to all 4 of those questions, the association's likely going to have to send a letter to the third party requesting a cease and desist of conduct, right? That's usually the first thing, right? We're not handling the criminal side of this or anything else. It's a civil, right? The covenants are a civil contract. So we're looking at it from that perspective. We want to communicate with the person who has made the complaint that the association has taken action. If we have taken that action, let them know that. And we want to follow up with the aggrieved person to see if the conduct has ceased. Now, let me be clear. I say this in another slide, but let me just also point out, the association is not law enforcement. If the conduct that takes place is of a nature that is so severe, or the aggrieved person feels though they're in imminent danger, what do they have to do? What is our immediate advice? It's going to be, you have to contact law enforcement. You have to file a report, right? The association is not going to provide that sort of security. What we're looking at is there a covenant violation that we can pursue? That's what we're looking at, and that's the analysis. But if this is a serious situation, by all means, law enforcement does need to be called and addressed, and they have to handle that as well. We are looking at it purely from the perspective of, is there a covenant violation happening? Can we take action based on that covenant violation in these scenarios? I hope that makes sense, but I always want to stress that if there's something that's very serious, you got to get law enforcement involved, right? And I pointed out there, but I just wanted to make sure I really highlighted that. Now, assuming that the conduct ceases, great, we don't have to do anything, but anything further. But assuming that the third party does not, they either ignore the letter or they keep doing the conduct that was unwelcome, what is the second course of action? Well, we may have to send a further letter. We may have to include the notice to impose enforcement remedies, what's available to us in our governing documents. We want to check to see if there's any ADR, alternative dispute resolution provisions, that we may have to follow. All of that, just similar to any sort of covenant violation, right? That would be the same sort of approach that we would have to take. And if they continue to ignore the demands, the third course of action ultimately would probably be filing a lawsuit. I said ultimately and probably. It would be to file a lawsuit. That would be the next stage. If we're not able to get any sort of further demands, we have justification to send this, we have justification for the enforcement remedies, we would likely have to file a lawsuit. And the injunction is going to seek for that third party to cease and desist the discriminatory conduct and to ban them from use of facilities or attending association functions, especially if that is where the altercations are happening. What are the costs associated with these complaints? So first off is, we look at the tangible costs of course, and I look to the right side, which is that assessments could be increased over time to cover the attorney's fees or increases in insurance premiums. If we were found to be in violation of fair housing, we'd have penalties, punitive damages. So the costs associated with these complaints, if we can't get them resolved or address them properly, it can be very costly monetarily. But there's also a cost associated with everyone's comfort in your community as well, right? Because people do talk, and we know that there's social media and that there's Facebook pages and community pages, and people will post information. And members may hear from neighbors about situations going on, but they may not get the full story. And hearsay can be very damaging. It can create inaccurate statements and a lot of confusion, right? And it can cause mistrust and anger within your community. You don't want to have any of that. You don't want the monetary costs. You also don't want the mistrust and anger in your community as well. So we want to handle these complaints in a timely manner. We want to go through the analysis now that we know the HUD rule that's in place. And we want to make sure that we take the actions that we need to if it is provided. And that's what I want to stress, is that this is not automatic. It's going to be based on what's in your governing documents. So let's practice. All right. I'm going to give two scenarios, two case studies. I'm going to read them to you, and then we'll go through the analysis step by step. I'll also add one other story that actually happened for one of my communities last summer and how that got resolved as well, and time permitting. But I think I have time. I have at least, in my mind, I have about 14 more minutes before the Q&A. So I think we're good. Okay, so here's the case study number one. So Peter Schwarzenegger is an Austrian immigrant who owns a large pit bull. 2 weeks ago, the dog bit another resident. By the way, this is based off a real life fact pattern. Names have been changed, obviously. 2 weeks ago, the dog bit another resident named Bob. Bob complained. So the board met and determined, based on their governing documents, that the dog would be dangerous and needed to be removed, sent notice. Beautiful Gardens HOA sends the violation letter to Peter. Peter responds, and he says that the dog is an emotional support animal. So this does relate FHA-wise because we're dealing with a reasonable accommodation, right? He's asking, he's saying, I can't remove it. It's an emotional support animal to help with his crippling anxiety. And he provides a note from his peer support group to support the contention. All right. Ever since the attack, Bob glares at Peter in a menacing and intimidating manner, and he has started yelling at him more recently and calling him a Nazi. And yesterday, Peter informs the board of this interaction. Now, this is important for a couple of reasons. First off is that no situation is ever unilateral, one direction. There's only one person involving this. It's layered, right? We have multiple situations happening simultaneously here. Another reality to these fact patterns is that it's also based on what is shared with the board, right? I'm letting you know in this situation, Peter has told the board of this interaction, right? But the board is not supposed to be the police. The board is not looking at everyone's social media and figuring out what's going on and who likes who and what's going on. You're not. It's based on the information that is shared with the board as well. So I want that to also stick with us. But we have two scenarios. Bob has been injured because a dog bit him. It's Peter's dog. And Bob has also verbally accosted Peter, calling him a Nazi. And based upon his national origin, that would be where we're falling into the FHA situation as well. So what should the board do? All right, as I mentioned, we're going to talk about that analysis. So we're going to use our questions and we're going to answer that. So number one, is the aggrieved person, in this case, that would be Peter, is he in a protected class? And the answer would be yes. We recognize that this is going to be based off of a slur, a derogatory statement that's based off of national origin. So we are going to say that this is, yes, this falls into that category. Was the conduct, the name calling, unwelcome? And the answer would be yes. We would say that, yeah, that was unwelcome. Based on what Peter probably told us or shared via email or however he communicated it to the board, it was certainly unwelcome. Did that person have their right to enjoy their home or use the common areas? Maybe he was walking into the car, whatever it was that interfered with by a third party, namely Bob? And the answer would be yes. In this situation, he probably would have explained the circumstances and said, yeah, I don't feel safe. I don't feel safe walking to my car. I don't feel safe walking from whatever that is, right? That's the scenario. So the last question, the most pertinent one, is does the association have the authority in their governing documents to correct and end the discrimination? And of course, I have to give you some facts. Otherwise, you don't know how to answer this as much as I do. So let's assume that Beautiful Gardens HOA, their governing documents include a too vague nuisance clause. There's many clauses out there that are too vague and unenforceable. I can't do anything with them. So let's say they do have that. So that's not going to be helpful. Let's say they do have the catch-all provision that says the owners must comply with the local, state, and federal laws, codes, and ordinances. Okay, so that's there. And they have a pet restriction that says dangerous dogs can be removed with a court order, right? So we're not going to physically remove the dog, but we could go to court and demand it. That's what the restriction says. Okay, so based upon these governing documents and the provisions, we could apply this HUD rule and say that owners have to comply with all local, state, and federal rules. That includes the HUD rule, that includes FHA. So there is some argument going on. Do we have multiple issues? Yes, absolutely, right? We have a situation with the emotional support animal and the dog with Peter. We also have Peter making complaints saying that he is a aggrieved person based on a protected class and that he is being threatened and harassed by Bob. So we have these two situations going on at the same time. What should the board do? Let's go through the answers. A says the board should send letters to both individuals and advise that this is a homeowner to homeowner dispute. Let the parties hire the attorneys and fight it out themselves. Now, we all know that's not the right answer because we've just said that the HUD rule exists. So if you think A, can't do that anymore. B, it says meet with Peter to discuss the dog's aggressive behavior and how to better control the dog. C, send a cease and desist letter to Bob to stop harassment of Peter. D, none of the above. Or E is B and C. And so you're probably guessing where I'm saying, because I've been harping on this, that there's multiple issues, but the answer is E, right? Sometimes we have to do things simultaneously. Sometimes we're doing multiple things. It's not just one answer. But in this situation, in the best case scenario, what happened in real life was that they have to meet with Peter on the issue of the dog's aggressive behavior and how to better control the dog. Because if he is making the request and reasonable accommodation that this dog be allowed to remain, the board has to approve that request, but also have a way that this is addressed. I've had situations like this where there has been an aggressive dog and they were able to show support and show evidence that this was an emotional support animal that could remain. And we've had situations where the agreement for the dog to remain was that the dog was not allowed to be out without a muzzle, or that just had to stay in the backyard or in the home and not to be walked, to again prevent further aggressive behavior and controlling of the dog. So there are ways to help address that, and we have seen that before. But definitely they need to meet with Peter about that issue. But based upon what's in their governing documents, they would also need to send a cease and desist letter to Bob to stop the harassment of Peter, to say that this behavior is not acceptable. It falls within this the general catch-all provision. There's a HUD rule in place, and you need to stop. And the hope would be that Bob would stop after that. Again, if not, we would take those further courses of action. Another real life scenario that I've put in here, I haven't put any names in this one, but this is a real life scenario that happened in Buckhead. Actually, no, I think this was Midtown. It was definitely a high-rise condominium. An older female owner sees a young man standing near a nice Mercedes within her condo building's parking deck. She immediately suspects that he might be trying to steal the vehicle and begins shouting at him, asking him where he lives, what he's doing here, and whose car he is standing next to. And it turns out that the young man owns a unit in the building and the vehicle is his. And in this scenario, this is based on real life, that the woman was white, the young man was black. Now, the young man records this incident on his phone and he posts it to his Instagram. A friend and neighbor sees this post and then shares it to the condominium Facebook page. It was taken down shortly afterward for violating the admin's protocols. There are certain protocols on what can be shared, but a board member did see it. Now, the important part of why I say this is that this situation happens a lot. And in fact, once I finish this case study, I'll go into the scenario that I had for one of my communities last summer. But it was the same idea, is that the board became aware of the situation because of, again, video and it being shared on a Facebook page, a community page, for which they saw it. And because they did see it, we do need to perform that analysis. There are times, though, that situations like this happen that it's not shared with the board. The board is not all-knowing. We cannot know all of the scenarios that take place. It is when it is brought to our attention. But here, what I want to point out is that the young man is not the one making the request. It was shared by someone else, and that is important in this analysis. So first off, board member sees this, is made aware, shares it with the board. So the board needs to have this analysis. Is the aggrieved person in a protected class? Yes. Was the conduct unwelcome? Yes. Did the aggrieved person have their right to enjoy their home or use the common elements and facilities interfered with? Yes. And finally, does the association have the authority to correct and end the discrimination in their governing documents? So let's assume, for purposes of this scenario, we have a valid nuisance clause. We have something that's fairly enforceable. And we also have the catch-all provision, right? The owners must comply. It's a condo document. Many condo documents usually have that language. Let's say they must comply with the local, state, and federal laws, codes, and ordinances. So what should the board do in this situation? Well, let's discuss. First off, as I pointed out, the young man did not bring this to the board's attention, right? It didn't get shared directly. They were not asking for intervention. So because they didn't, I would say in this scenario, the first thing to do would be to contact this owner, because he is a unit owner, and let them know that this was posted by this certain person. It was posted very briefly. It was taken down, but the board is aware of it and wanted to know if this was something that the aggrieved person wanted the board to be aware of or to take any further action if we have the right to. And get their thoughts, because again, it's based on whether or not they bring that claim forward. But let's assume that the person says, yes, I would. Should the association pursue this? Now, based on what I've given you, we've answered yes to all of the questions. And for the governing documents, we have language that would allow us to be able to send a cease and desist to this owner, the woman who was shouting at this young man. What provision is most germane? You'd probably use both, but definitely the catch-all provision would have been the most germane to this scenario because it's saying that you must comply with the HUD rule, the federal laws. That includes the HUD rule. So we'd be able to cite to that and say that you can't make these types of accusations or threats because it's creating kind of a hostile environment. And lastly, would this be enforceable? And the answer would be yes, I would argue that it would be enforceable. We had this situation happen. As I mentioned, this is based on a real life scenario. Not only that, because it was the parking deck, there was also a video camera. So there was a way for the board, once they communicated with that person, they were also able to find footage that showed that incident as well. And they were able to send a cease and desist letter, and that person did stop. There was no further altercation. There was no further incident between those two individuals, but there was a letter that was sent based upon the facts that I've shared with you. Interestingly, I've had a situation similar to this as of last summer, and it happened at this was a single family residential community in Cobb, and it was based off of, I apologize, it was based at the pool, sorry. So what had happened was that there's a couple things. It was a white woman who was heavily intoxicated, and it was a family, and it was the 18-year-old sister. So she was not a minor. She was 18-year-old, and she was bringing her family. It was the summer. It was June. They was coming in middle of the week, coming to let her younger siblings come to the pool, and she was taking them with them. They're longtime residents. They've lived there. Owners lived there. Her parents are owners, lived there for a long time. And the minute that they came in, even though they had the key card and had access, were immediately accosted by this woman asking, why are you here? You should not be here. You need to leave. You don't live here. All this. I'm going to call the cops on you. And the young woman was very composed, given the fact that she would have been very scared, but she called her mother. And her mother came down to the pool and asked her daughter to film. So what we wound up seeing, and I will get to it, is that it wound up being a video that was up for a very short time on the community Facebook page that night. That's how the board learned of it. But the daughter captured it. The mother was very calm, was explaining, we are residents, we are allowed to be here. I've asked them to come so they could have a good time. Both parties called the police. The police wound up coming. And funny enough, they were very familiar with the woman who was accosting the family because she had been asked to leave on other occasions. This was not the first time, but first time for this family. And so long story short, the police did ask her to leave. And the family, especially the father, was upset. And so he posted it on the community Facebook page. It was taken down shortly thereafter, but the board did see it. And of course, the next day I wound up getting a phone call asking, what should we do? So we had to look. We had to do the same analysis. We asked the questions. Yes. We are, in the protected class. And I apologize if I didn't say, I did mention that she was white. The family was Black. And in the protected class, the conduct was unwelcome, certainly violated and interfered with their rights. And their governing documents, unfortunately, did not have much. However, they had very established pool rules. And in their pool rules, they had this, first incident, first violation, it was, you get a warning. Second violation of the pool rules, you get, I forget what other notice, but it was by the third time, you get suspension. You get your rights to go into the pool can be suspended, right? And so we actually were able to utilize that because this owner had received multiple notices previously about no smoking. There were other violations that she had. So we were able to utilize that rule to send us basically a violation notice and a suspension notice that she was suspended from using the pool for up to 60 days. That's what was in their governing documents. You can't do a max. The suspension was the max of 60 days. So long story short, we were able to send notice. We spoke with the aggrieved party, let them know what was going to happen. We suspended her access for the remainder of the summer until the end of August. She did not come back to the pool. She was upset initially, but did cool down and did honor that and did not attend the rest of the kind of pool season until the end of August. And we were able to resolve that. But again, it comes down to what was in our governing documents. With that, I know my little timer went off, so I'd have time, Melissa. So I have, I think, about 10 minutes or so, but I wanted, first off, thank you all for listening to all of this. I hope it was helpful to you, especially when we can do real life scenarios or case studies where we can actually analyze it together. But if you have any additional questions, please let me know.
So I thought this was actually fantastic. As uh, you know, I don't manage any communities specifically in what it is that I do, but I've been a community manager for so many years. And I cannot tell you how many times these particular topics come up. And I wish these were isolated events, Cindy. As we talked
I
about
know.
this tonight, it more than anything really kind of breaks my heart that we even have to have discussions like this. And I remember when this ruling came out, how it rocked all of us, because before, as managers, we got behind it's a homeowner to homeowner dispute. You don't have to get involved. The association has no authority here. And now with this ruling, we absolutely do. And I think all of the guidance and all of the almost checklists that you gave in these slides are so incredibly helpful in just allowing us to help not only guide the board during the situation, because of course, for those of you watching, you may not be professionally managed and some of you might be. And so if you do have the privilege of having a community manager, sometimes some of what Cindy's slides offered, we can kind of have those conversations and then go ahead and get that attorney involved, especially when we have to issue those cease and desist if those have to happen.
Right.
But
And it is an if, right? It's not always guaranteed. I mean, my scenario, the reason I wanted to use my scenario from last summer was, and it wasn't the only one, it's just the one that I feel like most, can apply easily in this seminar. But without that pool rule, we really would not have been able to do anything. And I point that out, is that it's not that we automatically always going to be sending a cease and desist in these situations. It really does come down to what's in the governing documents. Had it not been at the pool, had it been, not the fact pattern that we had, and we didn't have that specific pool rule established, we would not have been able to do anything. Like, that would have been what we'd have to explain to the aggrieved party, was that under the governing documents, we just don't have anything that we can bring forward to say that they were in violation, right? But fortunately, in that situation, and I say fortunately, is that I do know that the board wanted to do something, if they could, was that we had that pool rule, and that's really what it was. But if absent that, we would not have been able to send any sort of cease and desist. We would not have been able to handle that. But that doesn't always make people feel as safe or as comforted as well either. So we were able to find a good resolution in this situation, and also hopefully help that particular person, that owner, that third party, realize that they should not be approaching a family like that. They should not be doing things like that. We know that that should not be happening. But again, absent that rule, we probably would not have been able to send anything, because their governing documents just did not have anything that would be helpful in that situation.
I also really like that you pointed out and kind of wove it in a few times during this discussion. And super shout out to you for that. Thanks a bunch. But you wove in that although, yes, we, as a managing agent and even as an attorney, the board has a responsibility in certain circumstances to act or respond and reply. We are not the end all be all and all knowing of things. Sometimes the police do have to get involved, and that is not something that we as management companies or legal counsel can do on behalf of our board members or our partners. And that also it only supports our ability to be able to really kind of break this information down when we have that supporting information and it's brought to our attention, right? So I think you did such a fantastic job in really delineating and pointing out those particular nuances, because to your point and what you were just saying, one, not every opportunity is something that we can address. And two, if we don't have all of the correct information or all of the parts of the knowledge to be able to help a circumstance, we may not be able to move it any more forward than those particular aggrieved parties would want us to go or would like the circumstance or outcome to be. So I loved, and I thought you also did a really great job of kind of recapping a lot of what was explained in the first class. So especially for those of you who have not had a chance to join us in the first class and have to catch that on replay, she did a really great job in just kind of consolidating those key points. we haven't quite gotten a whole bunch of questions yet, but we did get one very early on, and I think it's an interesting question. I'll put it that way.
Okay.
It is based on the protected classes broad definition. Essentially, anybody could be in a protected class. Would you say that that would be true?
That certainly has been brought up in other FHA seminars that I have not only taught but also just been in when I'm, from a legal side for continuing education. I mean, the answer is yes. I mean, really, the protected classes are in such a way where someone could try to argue that, yeah, based on their site, depending on what it is, yes. But it's also from the standpoint of this, it's the protected class, but it's also the unwelcome contact. It's the harassment. But to answer that question very generally, it's like, yeah, there is an argument that anyone could fall into a protected class. Absolutely. And but it does come down to the conduct and in this case with the quid pro quo and the hostile environment. So is it creating that sort of hostile environment? Are they being targeted? Are they being harassed because of, again, that protected class, what they fall into in that protected class? But yes, I mean, because of the broad nature of it, it is arguable that, yeah, anyone could fall within one of, if not more than one protected class.
Sure. And I think this is where especially as community managers, when we have to have conversations with homeowners or with board members, like what's that line there? I think you also did a really good job of kind of pinpointing that it's not enough to just have that be present. It's how is it being applied in the circumstance? Is there that tie? Is there that nexus that you were talking about that says, hey, listen, it's because of this particular what we learn as fresh corn? Is it because of one of these things that falls into this status that is being present in this particular circumstance that then makes it something that is, in the fair housing capability? So this is why we said kind of early on, and actually even in the last class, it might be a little bit difficult for questions to kind of come through because so many things have to be so specific. There are so many parts that are at play when we're talking and discussing it. I don't know if you have, other than the recommendations, obviously, that you talked about here, we certainly don't want people tattling, or breeding that environment of like, well, I saw something happen. Maybe I should make the board aware of it because I'm not really quite sure. This is also where that third party capability comes into it. Well, if you weren't the person that, it actually happened to, how do you handle that particular circumstance and so forth? And obviously with social media, which you addressed, with social media being such a high presence that it is in a lot of communication and people's ability to kind of pass along feedback or information that they've learned, sometimes we are learning a little bit more about circumstances and do have those abilities. But I will say, obviously, we want to be made aware. We, management companies, boards of directors, I'm sure probably want to be made aware of circumstances because the general consensus is we want people to enjoy the community in which they live, right? And I think you had
Absolutely.
mentioned this in one of your earlier slides. This can breed so much contention, right? And we don't want people living in a place where they don't feel like they can share their thoughts or their comments online, where they don't feel like they can use the common areas and go to the pool and enjoy themselves with a guest or with their other family members. And when it's impacting your ability to have that access to be able to enjoy the things that are a benefit to you as a result of being an owner or living within that community, those are the times that you really, I would think, would want to make sure that the appropriate persons are aware of circumstances if they can be addressed. So, it's a little bit difficult. This is a very large topic. And I just want to say, I think you've done a fantastic job. As Cindy had mentioned, I think you said you taught about 13 management companies last year, which I think is fantastic. Thank you for what you do and providing us access to be able to have this information. I love that you also pointed out that it's not just enough for board members to be educated or homeowners to be educated. We as your agent have to be, have to be educated, and that attorneys also have to look at it from such a fair and balanced perspective. So I think all of these things are really important when we take a look at this particular topic. So we actually don't have any more questions. I loved the question that was asked because it did generate a very common thought that happens. And I guess I would just say, just like as Cindy said, it depends on how it's applied, right? It depends on that particular circumstance. And if we know certain things are to be true, you might not know them at the very beginning, right? You might not know that when somebody submits a modification request that there are hidden things that are potential until that person possibly tells you, or violation notice, unfortunately, like that first note, that first example came through happens. So
right,
it's
with the
not
dog
the
bite.
board's
Yeah.
it's not the board's intention to come through the community and make everybody's life difficult. The board is tasked with also making sure that the harmonious environment is maintained within the community. So I thought you also did a really good job of really pointing out how governing documents can really help or hinder situations, and that they are not all created equally,
No.
and it can be really detrimental even in the best of situations and the best of intentions to get things taken care of. And of course, pointing out too, unfortunately, these things can be very costly. So I know this sounds super cliche to say this, but it would be really beneficial if we could all find good ways to treat each other as neighbors and to really try to take down defenses whenever possible and try to find solutions before having to have things be escalated. But some things are just unfortunately unavoidable, and they do need to have the appropriate attention required to getting some type of reasonable resolution. So I know these topics are not very fun. They don't leave very good taste in people's mouths, especially if they have ever had any first-person experience with any of them. But just know that, as you can see from our course tonight, we try to partner with really great professionals that are experts on the topics. We bring those expert solutions to all of you in our Heritage University classes. And for those of you, if this is your first time joining, what I love about our courses here for Heritage University is you don't have to be a Heritage client in order to take advantage of this. You don't even have to be a board member. We want you to enjoy living in the neighborhood, and we want you to potentially be able to serve. And so maybe if you're just a homeowner that's watching this, or maybe you have just some curiosities about what living in a community restricted, association would look like. Hopefully you find value in some of these course contents so that you can be empowered and feel like you're a little bit more educated so that you can be helpful. And maybe one day you would want to serve. But again, if you are a board member and you want to be able to represent your community, showing up in places like this where it's a whole hour of your time after you've probably had a long day of work or are doing other things and are appropriating time specific to this, I think this is a great way to showcase to your community that you're listening, that you're engaged, and that you want to represent the best features of your community. So don't be afraid to share content like this. Like I said, we want this to be completely educational and empowering to each of you. So thank you so much for carving out some time in your evening, Cindy, for teaching this course for us, and teaching 2 courses for us, not even one. And for those of you that signed up for tonight, you are also getting the access to Cindy's bonus content, where we talk about loan approvals and the whole process for condo certifications and all kinds of other things. So for those of you that joined us tonight and registered for this class, you are going to get that awesome exclusive bonus content. We're also going to provide you with some really valuable resources. Cindy had kind of dropped it a couple of times in her content, but we're going to give you a nice code of ethics, and we're also going to armor you with CAI, which is Community Association Institute, which both Cindy's law firm and Heritage are proud partners of, and we love helping. And in fact, I lovingly serve on the education committee with Cindy for our Georgia chapter. So you can tell that we're both very invested in education, but we're going to provide you with the civility pledge that CAI offers as well. So we want to make sure that you as board members have that ability to promote, like Cindy was talking about, how can you better represent and let your community know that you take these things very important, and that, these topics are something that you want to make sure that everybody knows that you prioritize as well. So we're going to give you those really great resources. And we thank you, all of you that are watching us live. Thank you so much for carving out time in your schedules to be able to join us. And for those of you that are joining us on replay, hopefully this is not the only piece of content that you're going to be looking at, and that you're also perusing our large library on our YouTube channel. So for all of you in the audience, thank you so much for joining us. Cindy, it's always a pleasure. We adore you. We thank you so much for your partnership and the kind words that you've said about our organization and our team. And we look forward to seeing all of you again in the audience soon.